Article 23(1) of the Constitution. This petition alleges what the petitioner perceives to be violations of his right to fair hearing, a right in the Bill of Rights. Whether the right to a fair hearing has been violated is a matter within the jurisdiction of this court. I must add that the right to a fair hearing is guaranteed by Article 155 is one of the non-derogable rights in Article 25C. In Evans, Gidero, and others, the Supreme Court did consider the matter understated in reference to Article 50 sub Article 1 that the right to a fair hearing for all persons under Article 50 sub Article 2, which accords all persons the right to a fair hearing, that are used interchangeably, sometimes to define the same concept and at other times to connote a minor difference, thus fall under the list in Article 25C, which lists the right to a fair trial as a non-derogable fundamental right and a freedom that may not be limited. The petitioner also argues that the constitutional imperatives in conducting public participation were not met. This falls within the scheme of Article 165 sub Article 3, so that this court has jurisdiction to interrogate whether any of its processes or any of the constitutional processes said to have been conducted under the authority of the Constitution met constitutional threshold. In that respect, the issue raised in the petition centers on whether the petitioner's right to a fair hearing guaranteed by the Constitution has been violated and whether anything said to have been done under the authority of the Constitution and any law is inconsistent with or in contravention of the Constitution and therefore falling within the jurisdiction of this court under Article 165 sub Article 3, B and D. Article 165 sub Article 6 further grant this court supervisory powers over anybody, on a person or body exercise judicial or quasi-judicial function, including the National Assembly and the Senate when performing quasi-judicial functions. The first respondent has pushed an argument that this court has no jurisdiction to hear matter arising from impeachment of the President or Deputy President on the basis of Article 165 sub Article 3C. That article provides the High Court has jurisdiction to hear an appeal from a decision of a tribunal appointed under this Constitution to consider the removal of a person from office other than a tribunal appointed under Article 144. Article 165 3C is in relation to the process of removing the President or Deputy President from office on grounds of incapacity. This process is initiated for the investigation of the President or Deputy President's physical or mental capacity to perform the functions of that office. This is a distinct process from the impeachment process in Article 145 as read with Article 150. Article 165 3C excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Sub judice, the respondents again pushed the argument that the application is sub judice in view of the application that was in petition E522 of 2024. All sides agree that in that application the issue of conservatory orders was not pursued. This was based on the fact that the process in the National Assembly had concluded. Indeed, counsel for the petitioner read to court an excerpt of the ruling from Judge Mugambi's decision, where the counsel for the first respondent informed that court that the process in the National Assembly had been concluded. In constitutional petitions, it's quite normal for parties to come to court and within a short time, find the circumstances of their cases having changed and may only have to take other steps to bring life in those disputes. The court, having not dealt with the issue of conservatory orders in that matter, I say no more on that issue. The issue next is whether this court should grant a conservatory order. The petitioner has urged the court to grant a conservatory order and halt the process that is pending before the Senate. The petitioner's case is that the process is violative of his right to a fair hearing and that constitutional imperatives on public participation were not met. The respondents urge the court not to injunct the Senate since it is undertaking a constitutional process authorized by the Constitution itself, and the parties have relied on several decisions to support their respective positions. Parliament is an institution established under the Constitution. It comprises the National Assembly and the Senate. The National Assembly considered a motion to impeach the petitioner and passed a resolution. This was in exercise of its mandate under Article 150 as read with Article 145 of the Constitution. Article 150 on the removal of the Deputy President provides, I have provided that, I don't have to read it. Article 145 provides for the procedure for removal of the President by impeachment. A member of the National Assembly, supported by a third of members of that House, may move a motion to impeach the President on grounds of, namely, gross violation of the Constitution or the law, where there are various serious reasons to believe that the President or Deputy President has committed a crime under international law or national law or gross misconduct. If the motion is supported by 2/3 of all members of the National Assembly, the Speaker is to inform the Speaker of the Senate within 2 days. The Speaker of the Senate is then to convene a meeting of the Senate within 7 days after receiving the notice to hear the charges. Article 145, Subarticle 5 states that the President or Deputy President shall have the right to appear and be present before the special committee during its investigations. Where the allegations are substantiated, the Senate has, according to the President or Deputy President, an opportunity to be heard, vote on the impeachment charges. If at least 2/3 of all members of the Senate vote to uphold any impeachment charge, the President or Deputy President will cease to hold office. Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have read the decisions from the Supreme Court and the Court of Appeal, as well as those cited by the petitioners. The decisions have laid down the position that it is important to let the impeachment process run its course, and after which the court would have to look at any complaints for violation of either the Constitution, the law, or fundamental rights, including processes. For instance, in Julius Kariuki Mate, the Supreme Court stated that interpretation of the Constitution calls for a delicate balance in the respective mandates of the different arms of government. In the Sonko case, the Supreme Court observed that the removal of proceedings for a county governor are textually committed by the Constitution to the legislative branch of government. The Constitution mandates that the process to impeach a governor commences in the county assembly and terminates in the Senate. The Supreme Court emphasized that the Constitution commits to both institutions the exclusive power to remove the governor, subject only to procedural requirements set out in the County Government Act and the respective standing orders of the county assemblies and the Senate, and proof of the charges. The Supreme Court then added, it has been emphasized in accordance with the principle of separation of powers that in considering applications to review decisions of the other branches of government, courts should strive to achieve a balance between their role as guardians of the Constitution and the rule of law, including an obligation to respect what Parliament is constitutionally required to fulfill. In other words, where the Constitution requires Parliament to determine a matter in the first instance as part of its constitutional mandate, Parliament will have the discretion and the power to regulate its own affairs, and the court will be slow to interfere with the exercise of that discretion. Reference in this decision to county assembly can also be referenced to the National Assembly. Flowing from the decisions, where the Constitution commits a process to another arm of government, the court should allow that process to complete, that arm of government to complete its process before the court exercises its judicial review jurisdiction over the matter to determine whether what was said to be done under the authority of the Constitution is inconsistent with or in contravention of the Constitution. Granted, this is the first time this country is experiencing an impeachment proceeding against the Deputy President. The petitioner has raised substantial questions, including violation of his right to a fair hearing, guaranteed by Article 50 sub-Article 1 and ring-fenced by Article 25 sub-Article C as a non-derogable right. The petitioner has also stated that the National Assembly, in passing the impeachment motion, considered extraneous matters other than the grounds raised in the impeachment motion. There is a further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency, serial number 95, to demonstrate this fact. According to the results for public participation in that constituency, the total number of people who participated was given as 43. Those who supported were 70. Those who did not support were 3. The percentage of those who supported was 162.79%, while the percentage of those who did not support was 6.98. It is implausible that an attendance of 43 people would produce 70 people in support, that's 162%, and 3 people in opposition. The petitioner has raised valid concerns. However, precedents bind this court so that although the Constitution grants the court jurisdiction to intervene where there is a threat to violate the Constitution or human rights and fundamental freedoms, the court must exercise restraint in matters of impeachment. This process has been committed to Parliament, which must be allowed to conclude its part. In our constitutional scheme, the people delegated the authority to state organs, including Parliament and the judiciary, to exercise the delegated authority only in accordance with the Constitution. Article 2 reminds everyone that the Constitution is supreme and binds all persons and state organs at both levels, while Article 3 places an obligation on every person to respect, uphold, and defend the Constitution. Article 10 sub-Article 1 also is clear that the national values and principles bind all state organs, public officers, and all persons whenever they discharge their mandate under the Constitution. National values and principles include transparency, accountability, the rule of law, and public participation, as well as human rights. If a state organ fails to abide by any of the values and principles in the Constitution, the court exercising its mandate under Article 165 sub-Article 3 will come in and investigate whether anything said to have been done under the authority of the Constitution is inconsistent with or in contravention of the Constitution. It was in this respect the Supreme Court stated in a matter case that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted to the doctrine of separation of powers, to deciding on matters of individual rights and fundamental freedom. The Supreme Court then stated that in the exercise of their wide political powers, both the county, National Assembly, and the Senate cannot act outside the confines of the Constitution and the law. For to do so would invariably invite the court's intervention. End of quote. In other words, the constitutional processes are not about a dash to the finish line. They have constitutional imperatives that must be complied with, and if not, such infractions will not be out of reach of our Constitution. The timelines given in the Constitution are on the premise that its processes will be complied with, will comply with the constitutional requirements. Where there is an allegation that the constitutional imperatives have not been complied with, the affected person has recourse to the courts, and the court will rise to the occasion and consider whether the state organ complied with the constitution or the law. In that respect, ours is a constitution of hope and promise that institutions established under the constitution will comply with its fundamental principles, and the promise that the constitution is supreme and any act or omission in contravention of the constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is out of reach of our constitution. This is what Lord Denning had in mind when he stated many years back that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Article 2, Sub-Article 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and President, the prayer for grant of conservatory order is declined. However, in view of the issues raised in this petition, which also appear to relate to those in petition E522 of 2024, which has been certified for purpose of appointing a bench of an even number of judges to hear, I certify this petition as raising substantial questions of law and of public interest in terms of Article 165, Sub-Article 4 of the Constitution. This file is to be placed before the Honorable Chief Justice to consider appointing an uneven number of judges to hear this petition. Given the close proximity of the issues in this petition and those in petition E522, the Honorable Chief Justice may consider whether this petition may be heard by the same bench appointed to hear petition E522. I make no orders on costs. Thank you.
Your Honor, we seek leave to appeal the